an emergency clause on the original bill. There are also two amendments posted on OLS. The -1 replaces the measure and prohibits a suspension if the individual sets up a payment plan and begins making payments within 120 days of the offense occurring. It also explicitly authorizes the court to allow the individual to retain their driving privileges if the court deems it necessary. The -2 is essentially the same as the -1, but the 120-day timetable for entry into a payment plan starts at the time of entry of judgment.
All right, so gentleman who is going to take the lead. All right, Representative Gorsuch.
Thank you, Mr. Chair. Good morning, everyone. Nice to see you.
Good morning.
I am Chris Gorsuch. I am the state representative for House District 49. So good morning, Chair Brzezinski, Senator Thatcher, Vice Chair, and everyone else on the committee. I'm here today to testify in support of House Bill 4065. This legislation provides some balance, ensuring that we're using state resources in an efficient, cost-effective, and thoughtful manner. It's my understanding, as was also just stated by the chair, that the debt collectors have an amendment that I'm not really prepared to talk about since I haven't seen it. So I would direct any questions around that to the folks that'll come in behind me from the Oregon Law Center. But in terms of the original bill, we brought the bill because in Oregon, the inability to pay a traffic fine for minor offenses like failed to signal, broken tail light, and so on, can mean, if you're unable to pay for that fine, a suspension of your license. This can create a cycle for our constituents that means that not only do you lose your license, but it also takes away or hinders your ability to earn money to then pay the fine in question. As you will hear in testimony, there are some personal stories about people who've gone years without being able to legally drive. And that doesn't just mean drive to work. It also means being unable to take their kids to school, medically vulnerable folks to the doctor, and so on. The process becomes even more onerous as reinstating your license results in additional penalties and fees. Unfortunately, this experience is not uncommon. License suspensions have dramatic effects on people's lives, impacting their ability to pay other debts, housing expenses, rent, medical bills, and to provide for their children's future. HB 4065 removes the ability to suspend a driver's license for otherwise good drivers simply because of their inability to pay. The bill does still require accountability because these drivers are still responsible for their debt. It's not taking that away. It also leaves in place license suspensions that, as a former law enforcement officer, are near and dear to my heart, which is suspending people for failing to come to court, failing to appear. That is unchanged. We need to assure that we're addressing debt and instilling respect for the law. This legislation leaves intact the ability of the court to use private collections, wage garnishment, and requests to the Department of Revenue for the driver's tax returns. In passing this legislation, we would be joining other states, a fairly diverse group of states, actually, when you think about Montana versus Idaho versus Mississippi and California, all of which have ended what we consider to be an ineffective practice that has undue impact on people's lives. That's my testimony, and I'm here for any questions, but now I will defer to my colleague, Senator Manning.
Thank you, Representative. James Ivory Manning, Jr. I'm the senator from District 7, one of the best districts, Senate District, one of them. I'm in the
49 is pretty
Say there's
Okay.
1, 2.
One of them, okay.
So there's at least 6 okay districts. 1, 2.
I say one, Mr. Chair. Thank you. I knew I was going to mess that one up, wrong audience. I'm here today to testify in support of HB 4065. And my years in law enforcement and criminal justice have bared out the same thing that you just heard. Typically, you're talking about marginalized or communities of color that are really impacted by this. Now, citizens with means, this is not a problem. They pay their fine and they move on. They don't have to worry about suspension. But when you talk about struggling families trying to make the day-to-day, who's going to work, how we get to school, how we're going to provide, it becomes a struggle once your driver's license is taken, and it forces them to drive illegally. By taking a driver's license, it forces them. I was going to give a pretty lengthy statement, but of course he's nailed it. So I'll make mine very brief. I am reminded of Ferguson, Missouri. And Ferguson, Missouri came to everybody's kitchen tables when an incident that occurred between a police officer by the name of Darren Wilson and an 18-year-old Michael Brown. What that did was it uncovered a systematic effort for the city of Ferguson to use fines, suspend driver's license to fund their city projects. Not the people that had means. It was directed at 65% of that population, which is African American, low income. I remember recently, not too long ago, going down I-5. There is I won't call the name of the city, but they ran radar.
Can I help you with that?
You can.
The city of Coburg, that was bringing in over $750,000 to fund their city off the interstate where they had no jurisdiction to put them in their own court. I'm familiar with that one.
Thank you, Mr. Chair. So when we start looking at these practices that have occurred, it stands to reason that if we are using law enforcement, in fact, to raise revenue for city projects or programs, we have lost something. Our morality is gone. And it's not about the criminal justice system. I would argue that it's worse than that we need to investigate the practices. So I understand there is a -1, -2, which I do not support, and I will not support. I think this bill is fine as it is. Thank you very much. Subject to your questions.
All right, thank you. Questions for the representative or the senator? Senator Denbrough first, then Senator Gelser next.
Thank you both very much for bringing this forward. I happen to know that you're both police officers in recovery.
Yes, that's true.
And I'm wondering, given your background in law enforcement, whether you see this bill as beneficial or harmful to practicing officers. Put yourself back to your days in uniform.
I'll take the first
go
item. When I was on patrol, I had flexibility. It was up to me. I made a decision whether or not it would be appropriate. If the law was not, if it was only a violation, small, minor, whether I would want to take a family through all of that. One night, I remember I was on patrol, and I was going around this business. I saw a car that was parked on this dentist parking lot. I pulled in behind the vehicle, and when I pulled in behind the vehicle, I called in, did a radio check, find out who the vehicle belonged to. I approached the vehicle, and when the window rolled down, a puff of a gush of smoke came out. There were like 4 high school students in the vehicle. Now here, I had to make a decision. Do I arrest these kids and put them in the system for doing something that so many others are doing, or do I teach them a lesson? I decided to teach them a lesson. I had them get out of the car, dump all of their stuff on the ground, and I called their parents to come and pick them up because I did not want to put these kids into the criminal justice system for something that I thought they would only harm was to themselves. So, and they wouldn't be able to drive either. So that was one of the conditions that I did with the parents in order to let them go. So yeah, discretion is really important for law enforcement.
So, Senator Brzezinski, Senator Dembro, ironically, although we worked in different departments, we seem to have done it together because we used to do the same sorts of things in my department. Although usually it would be take the marijuana bag over and make the fishies high by dumping it down the storm drain, or alcohol. Either one worked. However, what I would tell you is that while it wouldn't such a change wouldn't have impacted me directly as a police officer, it certainly would reinforce our ability to try and make things work better so that low-income people are not being singled out. And I have to tell you, when you're working in law enforcement, you see poor people all the time who are getting into jams with the criminal justice system when other folks with more means don't. So while it wouldn't impact me directly, certainly the one thing that I would always be opposed to would be taking away fail to appear suspensions, which I think are a whole different category.
All right, any other questions? Senator, okay, sorry. Senator Gelser first and then Senator Lithicum.
Thank you, Mr. Chair. Thank you so much for your presentation. I think this is an incredibly important bill that will allow justice to be applied more evenly. A $50 fine is a lot different for a college student or a single mom than it is for Bill Gates, for instance. It's not an evenly applied penalty. You had mentioned that there are amendments. Nobody has visited me advocating for those amendments, and you, Representative Gorsuch, mentioned that you hadn't seen them.
That's correct.
Senator Manning, has anyone come to visit with you as a chief sponsor to talk with you about these amendments?
Thank you, Senator. I have been notified that there are amendments, and they're on OLS as well. So there are new, late arrivals. I think that it's all about collecting money. You know, I think that any programs that there are locally, there are alternative means to be look at on how to raise funds, you know, even if it's something that need to come to the Capitol. But looking at fines for driver's licenses as a means to fund city projects and programs is horrible, you know, because then you're saying that we are targeting specific groups of people.
And Mr. Chair, thank you. And I agree with what you said just there. I think the other thing that concerns me is that given it's a bipartisan bill with a bipartisan carry and a strong vote off of the House, it's surprising to me that if the debt collectors wanted an amendment, they would not go and actually have a conversation with the chief sponsors of the bill on a bipartisan bill. And just in terms of process, I think that's something that troubles me.
Could I, Senator Gelser, I completely agree with you. And the way I've always seen any sort of traffic violation ticket, it's designed to change behavior, right? So we give the ticket because somebody did something that they shouldn't be doing, whether it's making the wrong lane change or not signaling or whatever. But it is definitely, as my colleague has said, it is not something for police officers to be generating revenue from.
All right, Senator Lithicum.
Is there another panel coming?
Oh, there's plenty.
Oh, okay. Okay, good.
Yes.
I'm not sure my colleagues here are the ones to ask the questions to, so I can wait for others. At issue garnishment, failure to appear, all of those collections, all of those things. And it seems there's a fundamental difference between utilizing this to target a population like you refer to with Coburg, and applying the law evenly across all persons within our society. And that's the issue versus this as a tool to hold people accountable. Those are two entirely different topics. So I'd love to hear the conversation. Thank you.
All right, yeah, we're going to have some individuals, I think, that can answer that. I've got some stuff that I can also share as we get through this.
Mr. Chair, may I please just make sure that, you know, what the bill does, the bill does not prohibit law enforcement from enforcing the law. If there is a traffic violation, then they have to enforce the law. It does not prohibit them from doing that. Only thing this bill is saying is that you cannot use a driver's license as hostage for payment.
Right.
All right, I think that's well said. So it does, in fact, I do want to put on the record, the bill does not in any way impact or affect the discretion officers have in the field. So they can still make the same calls. It's basically what are the potential sanctions for someone who's failed to pay, and how do we handle that? All right, gentlemen, thank you very much.
Thank you.
We're going to go. Okay, so I'm going to go ahead and just start at the top here. We're going to kind of blend some different people in. Angela Donnelly, Ken, I know you're here for Mike, so why don't you come on up, and Matt Newell Ching, if y'all three will start off this next panel. I'll tell you what, before we do this, because we do have a number of students here, I don't know how long you're going to be able to stay here, but since you're here, could someone just identify what school you're? We're from Lebanon. From Lebanon. Wonderful. Well, thank you very much. And then I think another group came in the back. We're still from Lebanon. Wonderful. Thank you all very much for being here, and please stay as long as you can. Who'd like to start?
Good morning, Chair Przansky, Vice Chair Thatcher, and members of the committee. My name's Angela Donnelly. I'm from Bend, Oregon, but I now live in Portland. I'm here in support of HB 4065 and to tell you how suspending someone's license can affect them and their family. My mother's had a suspended license for over 25 years. This has affected every part of our lives. At the age of 9, my stepfather had an aneurysm and ended up dying within a few weeks of his stroke. When his stroke happened in our home, he was rushed to the hospital in an ambulance with my mother following him, distraught behind in her car. On her way to the hospital, she got pulled over and got a speeding ticket. This was the first ticket she ever had. She had a completely clean driving record. So within 2 weeks, my stepfather had died, the love of my mom's life, the father of my baby brother, the owner of the business that my mom worked for, and the main provider for our family was gone. So this, as you can imagine, drove my mom into a deep depression, and life was a struggle for her and us kids. The last thing on her mind at this time was her speeding ticket, and I really don't think she even knew that or remembered that she got one. So death and depression obviously aren't something that you snap back from quickly or sometimes ever. And while she dealt with this death, she also had 4 kids to care for. She had to find a job, provide for our basic needs, get us to school, find to friends' houses, families' houses, after-school activities, and also provide emotional support for her kids who were struggling with this death while dealing with her own heartache. So we soon lost our home. We jumped from family members to friends' houses trying to keep afloat. During this time, my mom had to continue driving because she had to continue trying to survive. We lived in Bend, which in the 90s was a really small town with no public transportation. And in the winter, the snow piles up and it's really unwalkable. So when you live in a small town, the police know who's who, and they knew my mom's car. They knew my mom's car and that she had no license. So she regularly got pulled over, got more tickets, more fines, more time added onto her suspension. Most of the time, her car was impounded, and we were left on the side of the road day or night to try to find a ride home. So it didn't deter her from driving, though, because she had to survive and she had to take care of her kids. As you can imagine, the fees piled up to the point where she didn't know what to do and just realized that there was no way she could ever pay back the debt she had, all because she didn't pay one ticket that was under $100. As a child, I went through this experience with my mom. I was often subject to the trauma that comes from dealing with our systems. I still get sweaty palms when a cop pulls up behind me. I snap back to that childhood fear every time of being pulled over, hearing the police treat my mom with absolute disregard and shaming her, forcing us out of the car so that they can tow it, and then driving away without a care for our well-being. It's real, and it happens to every one of us who aren't wealthy enough to pay our fines and fees. So having a parent with a suspended license made my life much harder. My mom didn't want to drive unless necessary, so I could barely make it to school functions. I had no one legally to teach me how to drive or ride in the passenger seat with me. So I couldn't even use my mom's car to take the driving test, and I ended up waiting years to get my license because of that. To this day, my mom still has a suspended license. Right now, my 59-year-old mom is riding her bike in Bend in the winter to work at night and home. A month ago, she was on her way home, and another person on a bike had a long pole on the back of their bike and it hit her. It hit her off her bike, and she broke a rib and bruised the whole side of her body. I spent years trying to get her license back. She tried to work with the courts, but they either won't offer an affordable payment plan or have such strict rules about missing a payment that she can't ever get it paid off. One of the courts she has a ticket in doesn't even exist anymore. Can any of you tell me how you pay a ticket or even make a payment plan when there isn't a court to contact? It's taken a lawyer and a legislator to help us to even start the process to get a hold of someone in that town. And we don't know if we can get that suspension removed, and we're just really hoping right now that someone will respond to us. I feel like my mom's one of the lucky ones in our state because I have experience navigating these systems and I know how the government works, so I've been able to help her. There's no way that she could do this on her own. Even if she could get all the courts to work with her, the cost of these tickets has grown over the years to a point where no payment plan can get her out of the built-up debt. She's still low income and barely makes enough money to pay her monthly bills. Paying these payment plans would make her homeless and unable to support herself and my stepdad. So I'll end up paying those tickets back for her. Without someone like me on her side, she'd never get her license back. But this doesn't mean she's not going to have to drive for the rest of her life. So I want to be clear, my mom's not been unsafe. She has not done anything in a car to harm another person. Suspending my mom's license has not made a bad driver safer. She simply could not pay a fine that she got 25 years ago and has been in this system that's designed to keep those in poverty and poverty since. The ability to provide for your family is not a privilege, and removing how you do that by suspending someone's license for a minor ticket is not how Oregon should treat her citizens. Thank you for your time.
Thank you. Who's going next?
Go ahead, Chairman. Good morning, Chair Brzezinski, members of the committee. For the record, my name is Matt Newell-Ching. I'm the Public Affairs Director for Partners for a Hunger-Free Oregon. This legislative session, I'm also representing Oregon Food Bank. An Oregon Food Bank on an average month serves an estimated 260,000 people in food pantries and other agencies in Oregon and Southwest Washington. Unfortunately, the stories that we have heard this morning are not uncommon stories. These are stories that happen in every corner of Oregon. And we're going to have other experts here testify to some specifics of this bill this morning. But Oregon Food Bank and Partners for Hunger-Free Oregon urge passage of HB 4065, and we urge you to do that as a clean bill as introduced. When we suspend a driver's license for a minor traffic infraction, and again, just to put some detail on this, this can be as simple as a failed turn signal or a broken headlight. A fine for that can cascade very quickly, and Senator Gelser made this point earlier, which is that for families who are already experiencing food insecurity, who are already having to make impossible choices between paying for food, paying for rent, do I repair my car? These are impossible choices that people have to make. And to pile debt on top of that and have debt cascade quickly. If the message here is that we want people to pay back that debt, it is counterproductive to take away a person's driver's license, which is going to harm that person's ability to pay back that debt. And again, we're not talking about DUIs, we're not talking about failure to appear. This is very narrow to minor traffic infractions. And so we think that this policy is something that harms Oregonians. We have a chance to do something this legislative session to protect all our communities. Senator Manning, I'm grateful for lifting up the impact that this has, this disparate impact this has on communities of color. I would also say that there's also a disparate impact on people in rural areas for which the necessity of driving is, or the ability to drive is a necessity for how you get to work. It's very difficult or impossible in many situations to rely on public transportation. And it's not only about getting to work, it's the stress of getting your kids to soccer practice, to school, to get to the grocery store, to do all of life's basics. We have stories of people who have come to our food pantries who, because they can't drive, they're literally limited in the number of bags that they can carry on public transportation. And so we know that ability and access for transportation is a root cause of hunger and food insecurity in Oregon. This helps address one aspect of that. We urge support for House Bill 4065. Thank you.
All right, thank you, Ken.
Chair Brzezinski, Vice Chair Thatcher, members of the committee, good morning. My name is Ken Sanchgren. I'm the Deputy Director for the Oregon Criminal Justice Commission and also the Program Director for the Oregon Statistical Transparency of Policing Program. I'm here to testify in place of Superintendent Travis Hampton with the Oregon State Police to discuss the racial disparities that we, both at the State Police and at the Criminal Justice Commission through the STOP program, have essentially uncovered related to this fines and fees discussion. And in addition to that, I'm here to say on the record that the Oregon Criminal Justice Commission is in support of HB 4065 as introduced. Superintendent Hampton has in the past, in different Judiciary Committee hearings, presented some data that his office has collected over a number of years that demonstrates that while the Oregon State Police stops residents of Oregon largely in proportion to the racial breakdown within the state, that when they encounter individuals who have either a suspended driver's license or are driving without insurance, that there are some pretty significant racial disparities once they encounter those drivers, and that those disparities primarily present themselves with African Americans, Hispanics, and Native American Oregonians. Interestingly enough, the Oregon Stop program, which I oversee, we arrived at a very similar conclusion separately from the Oregon State Police, and it was during a meeting with them that we decided to embark on a rigorous analysis to try to isolate the effect that encountering Oregonians with suspended licenses or no insurance would have on our overall analysis. So I know that I've presented some of this information to various iterations of the committee over time, so I won't go into too much detail. But essentially, in our report that we released in December of last year, we found that there was a small disparity for the Oregon State Police with regards to citations. After we met with the superintendent and we discussed the fact that he had, over a number of years, found that there had been disparities as far as encountering individuals with suspended licenses, we decided to, through our own causal analysis, take that information. The Oregon State Police was able to provide us with additional data that was not originally found in STOP, and we were able to apply that data. And what we discovered was that if individuals were not stopped or were not cited for driving without a license, driving with a suspended license, or operating without insurance, that would reduce the disparities that the Oregon State Police have in their citation practices by between 50 and 70%, depending on racial group. And so that is one of the reasons why the Oregon Criminal Justice Commission is in support of HB 4065. I think this is, as a researcher, one of the first times that we have one of the most rigorous analyses that we could conduct that could demonstrate the effect of a bill in a positive sense for improving racial disparities in policing outcomes in the state. Thank you.
All right, thank you. Before we take questions, I do want to correct the record. And Matt, when you made the comment as to who would apply to or what type of offenses, you made it sound like you were thinking that it only applied to violations, non-criminal, but it doesn't. It applies to any traffic fine that's imposed. And so I just want to put on the record for major traffic such as DUI, reckless driving, if there's a fine, it would also apply there, not just violations that are non-criminal. So that's just want to put that on the record.
Thank you for that clarification.
Yeah, and then Angela, it's very unfortunate to hear the story that you've told. I understand from your mother's perspective as to what she was dealing with and everything. Clearly, it's unfortunate because one, the officer didn't have the discretion or didn't use the discretion that they could have used. Two, I mean, to me, there would have been a legal defense as a prosecutor. If someone brought that to me, that I would say that was a choice of evils. Either get to the hospital, your loved one's dying. That seems to me that speeding a little bit should have been forgiven. So I apologize to you and your mother what they're going through. Questions for this panel? Senator Thatcher.
Excuse me. You mentioned encounters with people that have just suspended license, I guess. I want to make sure I'm understanding what you're saying. So there are disparities in encounters with people with suspended licenses, and the reasons for the suspensions were mostly because of unpaid fines?
Chair Brzezinski, Vice Chair Thatcher, we are unable in our data to discover what the genesis of the fine was. What we're able to see is if somebody who was stopped was eventually ticketed for operating without a license or operating without insurance. It is policy of the Oregon State Police to not pull over an individual for that offense, but if they encounter an individual after the stop has been made, then it is policy that a ticket must result. And interestingly, that's what fits with our data as well, that we discovered that the state police has no disparity when it comes to stopping individuals, but it's this post-stop outcome of actually then giving a citation for one of those violations.
And I guess I have one question. I think what the amendments do is give a grace period of 4 months, and in your case, it sounds like 4 months wouldn't be enough. What would be enough? A year, 2 years? What would you think would be a reasonable time for a person to enter into a payment program?
I think every person's different. I don't, and every situation's different, so I don't think I could put a time frame on it.
Understood.
Let me try to clarify on that. Normally, if someone is found guilty by the court, and let's just say traffic court, that's not a major crime, meaning a criminal action, usually they will ask the person at the time, either from the bench or if they have a person assigned to the court for collections, to set up payment plans immediately. And some courts have minimum amounts as to what they will accept for payments. But I don't think it's the issue of how much time precedes before you start paying is the issue, as much as having the obligation to be paying and not being able to make it. One of the things that I was very concerned with was ensuring that the court has accountability. And so requiring people to appear, and what I would assume would happen in this situation, if someone had failed to pay timely, the court would send them a notice, basically asking them to come into the court and show cause why they shouldn't be held in contempt for failing to follow the court's order of making these payments. And that's what this legislation says is that if you don't make the payment, that in itself isn't going to be the basis for suspending the license. But if you fail to come into the court and address the court as to why you weren't able to make the payments, and so you fail to appear, then that would be the accountability of where a suspension could occur. There's other tools in the toolbox that the court has, and we'll probably be hearing about them as we bring up some other witnesses.
Okay, and I also had concerns about penalties. It sounds like cascade effect, can't pay the initial bill, and then it sounds like probably penalties start adding up. Is that the cascade effect you're referring to?
Chair Brzezinski, Senator Thatcher, yes. It's our understanding that if an individual has a difficulty paying, like say for a $100 traffic violation for a non-criminal offense within 30 days, the court can add, something like $50 to $200 in fees. After 35 days, then payments delinquent and notice of suspension, is issued. And again, when you are fighting for every dollar for paying for food, for paying for rent, there are no dollars left at the end of the month. We put these families in very difficult choices. I'd also say that there are people more expert than I am from Oregon Law Center and others who can give
Just
more
generally, I was
details
just
there.
wondering if that's what you were referring
But absolutely,
to.
that is.
Well, it even gets more compounded, because if the court deems that they don't think they can collect it, or they have a rule that says we're going to keep these on the books for 90 days, 180 days, whatever it is, at that point they have an option, and most of them will refer it to a private debt collection. At that point, you have other costs and fees that are going to be added on top of whatever was owed to the court. All right, thank you all very much for coming forward.
Thank you.
Our next panel will be the Certified Smarts of Alicia Temple and Kelsey Hellman from the Oregon Law Center. So now we have the legals coming in.
We should clarify that I am not
And
familiar.
then Nikki,
Defer to Kelsey.
Nikki, if you'll come up as well. Yeah.
Chair Brzezinski and members of the committee, my name is Alicia Temple from the Oregon Law Center. Thanks so much for hearing this bill today, and thanks to everyone who came down and braved the traffic this morning to get here. As you've heard about this bill and ending license suspensions, these experiences are all too common. All of Oregon Law Center clients are low income and are living in poverty and are making those impossible choices. But beyond that, we know that people around the state are in this situation. It has, as I have worked on this issue over the last few years, it comes up over and over again as I visited DHS offices around the state. It came up from TANF family coaches as a barrier to helping clients move off of TANF and find employment. It comes up when you talk to housing providers about what's keeping people in homelessness, and part of the barriers, part of what got them there, and part of what's keeping them from being able to move out. It is wreaking havoc on all parts of our system and our social services, and we have other parts of the system that are compensating for the cause and the cost of these license suspensions. One of the Oregon Law Center clients that came to us with an eviction notice. The county ended up stepping in to help her avoid eviction, but the story came, as you traced it back, the eviction notice had come because her car had been towed. Her car had been towed because her license was suspended. Her license was suspended because she was taking care of her elderly mother and got us ticket and wasn't able to pay it. So those are those cascading consequences that we see, both, Senator Thatcher, to your point about the fees that are added, but then also how it impacts other people's parts of their lives. I just want to quickly address a few of the questions that have come up, and then I will turn it over to try to be brief. About public safety, Senator Dembro had asked earlier, and Senator Thatcher, your exact question came up in the House when Superintendent Travis Hampton testified about the data from the CJC about, do we know that these suspensions are specific to non-payment, and to quote Travis, to the best of my ability, he assured the committee that these suspensions on this issue is not at all about public safety. The state police do not view it as about public safety. They feel this is a separate thing, that it's about poverty, and that we are really causing harm to some of our safest drivers who aren't they aren't committing criminal offenses, they are just committing violations that result in fines. And so this isn't an issue that's about public safety. There are other mechanisms in the law to take care of people who are a safety hazard. Many issues have direct suspensions tied to it, so that's where the DUI, the reckless driving, other issues, if the behavior has a suspension tied to it, this bill does not change those suspensions. It also doesn't change the driver improvement program, which is where if somebody gets 3 tickets in an 18-month window, their license is restricted for a month. If you get 4 tickets in a 24-month window, your license is suspended. So we already have mechanisms to take care of our public safety concerns. This suspension that we're talking about in this bill is only tied to if you've paid or not. I will point out that the suspension for non-payment is for 20 years or until you can pay, but our safety suspensions are for a month or 2, which I think is an obvious disparity there. Want to address the question of accountability. So there are other things that we can do to make sure that people pay. Failure to appear suspensions have come up, and I think Angela's story is a great example of where her mother still would have gotten a failure to appear suspension. It's clear that she would not have been able to go to court in the month after her husband had passed away. But the remedy to failure to appear is appearing. It's going to the court. It's talking about it's participating in finding a payment plan, and it's showing up. It's not dependent on if you have money or not. And that's where I think our fundamental issue with this failure to comply suspension is that it's dependent on people having money. And if you don't have money, you don't have a remedy to it. But that failure to appear suspension encourages participation with the court, gets your attention, which we hear from judges. They like the tool of license suspension to get somebody's attention. It does that, but it has an easy remedy, which is participation with the court. There are also many ways to collect debt. We use debt collectors. All courts have access to the Department of Revenue to garnish tax refunds. We know that that is a prominently used collection method that works. If somebody has money, that can get money from them. So that is a way that we can hold people accountable. We want people to be responsible for paying their fines. We want people to still have consequences for their driving behavior. We just don't want it to have long-term ramifications for them. And the last thing I'll say is you've heard other states have implemented this policy. There are legislative and litigation happening all across the country on this. Idaho, Montana, Mississippi, California, DC, Maine, many others have done it or are looking at it. There is no data that shows that there's lost revenue after this change. California, in fact, is the only place where we have official data, and in that year following the change, their court system did not lose money. Overall, this collections rate went up 8.9%. They don't attribute it to this change specifically, but they both ended license suspensions and they overhauled their payment plan system. It's the payment plans that really have an impact on revenue, making lower barriers, making it easier, requiring that courts have written payment plan policies. That's all work that's in process outside of this building. And in the meantime, we can stop the harm of these suspensions so that we aren't putting families in those cascading consequences. I will stop there for time's sake and let Kelsey address some of the concerns we have about the amendments, and then we're happy to answer questions.
Thank you.
Mr. Chair, Madam Vice Chair, members of the committee, my name is Kelsey Heilman. I'm a staff attorney and I work with Alicia at the Oregon Law Center. Part of the work that I do is representing individuals who are trying to unravel the years of suspension and debt with sometimes more than one court across the state. And I'm here today to talk about the debt collector's requested amendment, which at first glance appears to be something of a compromise position, but on careful review actually preserves the status quo largely unchanged. So the first point Senator Przansky already covered, so I will make it briefly, which is that this refers to a court not being able to suspend if someone enters into a payment plan, but it does not change the underlying law that governs payment plans. And there is no underlying law that governs payment plans. Courts don't have to offer payment plans, and they can make the minimums whatever the court deems appropriate. We've done a public records request. We've seen payment plans from across the state. Many courts don't have written plans. When they have them, it's very common to tie the minimum payments to balance due, or to have a minimum time period as short as 4 months to repay. And so the court has to approve the payment plan under this proposed amendment. And if the court doesn't approve it, the person doesn't have any recourse. The second thing is the 120 days. So I'm going to address the -2 amendment, which tracks the 120 days from the judgment rather than the offense date. Right now, the earliest point in time that a person's license is suspended for failure to comply is 95 days after judgment. So what this does is gives another 25 or, yes, 25 days. I can do math.
Get the calculator quick.
Yeah, that's right. I'm a lawyer, not a mathematician. So it gives an additional 25 days. And in my experience, without fixing the underlying payment plan issues, that will not help our clients because they can't afford the minimum payment, and it's not that they need an extra 25 days to get the money together. Also, it's already true under existing law that if a person enters into a court-approved payment plan, the court informs the DMV and the DMV lists the suspension. So this really is not much of a change at all. And then finally, there's the provision that says there's no suspension if the court finds it necessary for the person to keep their license. Courts already have discretion not to suspend for any reason, including if they decide that the person needs to keep their license. But courts largely are not using that discretion because license suspensions are happening administratively anytime someone does not pay. So with that, I'm happy to answer any questions the committee members might have about the amendment or the bill in general.
All right, Nikki.
Thank you, Chair Przansky, Vice Chair Thatcher, members of the committee. Nikki Terzieff here on behalf of the Justice Action Network. We're new kids on the justice block here, and but not new to the work. And our membership is from ranges from Freedom Works all the way over to the Center for American Progress. And I think when you're pulling folks together like that on a policy issue, you've really got something right. So we're supportive of the bill as is. We would not be supportive of the debt collectors amendments. And I would just like to say, I guess this is akin to a conversation this committee very recently had, Mr. Chair, in your 1561, Senate Bill 1561, talking about a safe harbor provision and some mitigation periods and making sure that the systems are responsive to what is needed for the potential in the future of the folks that it's regulating and interacting with.
All right, thank you. Any questions for the panel? Senator Bembrow.
Thanks, Mr. Chair. I guess this is a question for Alicia. ODOT has some testimony on the record in support of this. And, I know when we've looked at earlier versions of this kind of initiative, I came to understand that there exists an American Association of Motor Vehicle Administrators, and which convinced me there's an association for everything.
They have very long reports.
Yeah, and they've done a lot of work in this area and setting a national agenda for trying to keep suspensions just limited to safety violations as opposed to being used for debt collection. And I know when we've looked at this in the past, ODOT has come in and testified to that effect, that this would actually reduce their budgetary requirements. It would help streamline their operations and reduce their costs. Did you yourself have conversations with them around this?
Yeah, so thank you for pointing out to their, drawing attention to their testimony. ODOT is formally supportive of House Bill 4065, and in the past, it did have a significant savings attached to it. This year, it just has a minimal fiscal, but they are really clear that they have 11 FTE within DMV, and that's spread out across the state, that they're are just for suspending and unsuspending licenses. They see this as a significant administrative burden that is really costly to their system. They would really like to be able to reassign that FTE out to their other big tasks that are coming up this year at ODOT. And so it's not a savings because they're reassigning those positions, not eliminating them, but they do spend significant FTE time, which they view as wasted on this process.
Thank you.
Yeah.
All right, thank you. Senator Thatcher.
Well, just a question. I wasn't sure if I heard you right, but it sounded like some other states that have tackled this also dealt with the underlying payment plan issue, and it sounds like we're not.
So this bill does not address the payment plan issue. That is something that courts can do at any time. And we've been having, we being the Oregon Law Center, has been meeting with the Judicial Department regularly about how we can look at that. They have a bill that I think should be here soon, House Bill 4142, that makes some small changes to start addressing some of those longer term payment plan pieces. The Public Safety Task Force is having conversations about fines and fees, and I suspect that that will be a part of that as well. And then we've also, again, we being the Oregon Law Center, have been presenting to municipal and justice judges and having conversations with them about the ways that they can do it. That is modeled after what California and also Texas and Florida and the different jurisdictions around the country have done, that has shown a significant increase in revenue and payment plan participation. We have a 12-step process that we think will help, that courts can do much of it at their own discretion, that I'd be happy to share our recommendations with you. But that's been an administrative conversation because it doesn't require legislative change to make happen.
Okay, thank you. But it does sound like there is a disparity between courts and how they do it. Sometimes just want it like within 4 months, whatever it is, whatever amount, and it still sounds like it might be impossible for some people. So rather than working with people, it sounds like there's just, I don't know, really disparate policies that need to be dealt with.
And it's something that we've had some work around on sentencing fines and posting bail and stuff like that. So some of this is going to need to be continued to be worked. But I think what we have here is a bill that basically says, let's stop the bleeding at the very top end, not worrying about having the payment plan being an issue by not allowing for the suspension to be exclusively on the failure to pay.
Yeah.
So with that, let me do this. We have another 2 panels I believe I need to get in, and we may have another bill. I do just want to put on the record, and we'll get corrected here pretty quickly. Alicia, you said something to the fact that the courts have the authority to go to the Department of Revenue. My understanding, that may not be for every court. So I believe the justice courts may be limited, but I'm going to have someone come up here because that's a conversation I had offline yesterday.
Okay. If I may, I've heard that some confusion on that question, but according to the Department of Revenue, all courts can use the tax refund piece, so they can't use the Department of Revenue as an ongoing collector, but all courts have and do use the ability to, and I shouldn't say all use, but courts from all sides of the system use the ability to collect from a tax refund using Department of Revenue.
All right, let me get one other clarification, because I also understand there may be a quote-unquote hierarchy as to who has first shot of getting the tax
That might be
recovery.
Yeah.
Okay, thank you all very much.
Thank you.
Okay, so our next panel is going to include Matt Marquis and Alex, why don't you go ahead and come on up? I'll bring the 2 judges up separate.
Chair, members of the committee, Matt Marquis representing the Oregon Collectors Association today. opposing the bill as drafted in support of amendments. And first, I just want to apologize to Senator Manning and Representative Gorsuch. I know I did not have an opportunity yesterday. These amendments came out fairly quickly and actually stemmed from a conversation with the chair late Tuesday. I do believe Senator Manning, I think Thomas from my office reached out to Senator Manning earlier this week about trying to work on a compromise, but I don't think we had a conversation specifically about this Dash amendment. So I do apologize for that. Time was scarce yesterday. I think we can all agree that there is a problem that needs to be solved here. You've heard some horrifying stories, and I can't disagree that we need to look at this issue. From our perspective, by taking away this this tool as a type of collections, it's a much more of a blanket approach that affects everybody. And you have to realize that some people in this society, for whatever reason, have means to pay, and they simply don't pay, and they try to work the system and do things around that. And to that extent, I talked to my client this week trying to figure out what their collection rates are on these types of debt across the state, and I kind of got an average across the state of somewhere around 20 to 25% of what's turned over to collection agencies actually get collected in this realm. But that really was different geographically across the state. And when you look at more socioeconomic, higher socioeconomic areas in this state, that collection rate goes up closer to 50%. And what that tells me is that people have the ability to pay, but without some sort of recourse, it's much more difficult to collect from those individuals. And so really what our amendments are trying to do, and are they perfect? No, they're probably not perfect. Is 120 days perfect? No, that's probably not. I tried to draft an amendment that didn't create this huge fiscal and put a whole bunch of requirements on both state and municipal and justice courts that created a fiscal. But I'm trying to find a way that we come up with a legitimate payment program, because as Senator Thatcher mentioned earlier, it seems like there's a lot of talk around what courts do, and you're right, all courts are different in how they work a payment program. But as soon as I get involved in starting to mandate what a payment program looks in this piece of legislation, I'm told that my fiscal goes way up. And I'm not trying to kill a bill, I'm trying to make the bill workable is really what I'm coming forward with an amendment to do. So yeah, I picked 120 days, 4 months from the date of judgment. I thought that was a reasonable time as far as trying to show, hey, can we at least enter into some agreements? And I'm trying to put some pressure almost on the courts, if you will, to say, yeah, let's do payment programs if there's a court out there that doesn't. The second piece of that, and I have to agree with the proponents of the bill, that yeah, judges have discretion today to do whatever they want as far as taking somebody's driver's license or not. Obviously, we're here today because they feel that judges don't use that discretion well enough. I would love to build in a hardship program at the court level that didn't cost money for the debtor or the person that owes these infractions, because right now, once you suspend your license, you pay a fee to get it back if you file a hardship program at Department of Motor Vehicles. I can't just take that fee away, because then all of a sudden we create a fiscal on the state. If I create a mandate on the judicial department or justice or municipal courts to say, here's what your hardship program has to look like, I'm told I get a fiscal there too. So I'm trying to put pressure to try to create some of these things, but without taking away just blanket carte blanche, we're never going to ever take a driver's license away again. And I do think there's a way to work a compromise here that works. Is the amendment perfect? It may not be, but I think it's at least an approach in the right direction. We've heard a lot of things about, well, somebody getting, a broken taillight or something like that, should they really have their driver's license taken away? Maybe we shouldn't, but we already have a statute in place as to what types of infractions should be there and should not be there. Maybe we should add some of these things to that list of infractions that shouldn't be used to take a driver's license away. I just think that taking a blanket approach isn't the right approach, and we need to look at the problem at hand rather than trying to legislate to one scenario, because I do think that scenario is legitimate and it needs to be addressed. I'm just not sure that it really is the right solution for everybody. And for those that have means to pay, I think we need to make sure that we have tools in our toolbox to make sure that those individuals can pay. It's my understanding, as far as a tax refund, I do believe justice and municipal courts have the ability to use Department of Revenue to try to, if you will, garnish a tax refund. I think that is accurate. I would just say not everybody gets a tax refund. And I mean, myself as an example, I think I am somebody that if I got a ticket, I should have to pay. I think I have the means to pay, I should pay. But there are often years that I don't have a tax refund. So if I didn't pay, they're not going to be able to get money from me being that mechanism. As far as the failure to appear, I do appreciate, I guess, that the ability to take somebody's driver's license is still there for the ability to pay. But we may disagree on this philosophically, but my client tells me numerous times that people do try to work the system that has means to pay. And if somebody just shows up in the court, they're never going to be able to take that driver's license away. So simply showing up doesn't necessarily mean that that tool is actually a tool there for failure to appear, because it is failure to appear, not if you appear. So again, we would like to try to work out a compromise. The -2 amendments may not be perfect, but we think that it is a step in the right direction. Thank you, Mr. Chair.
All right, thank you. Alex?
Sure. Mr. Chair, Vice Chair Thatcher, for the record, I'm Alex Kyler. I'm Lane County's Intergovernmental Relations Manager. I mark neutral on the bill. I think I have not taken this bill formally to our Board of County Commissioners. I can tell you that I think they would support the overall policy. Clearly, there's a lot of very credible people who have suggested this is good policy. The reason I'm here is because we have a principle in Lane County to protect existing revenue streams. And when I saw the revenue impact on this bill, which summarizes this will be a permanent reduction of revenue to both state and local courts, I started asking questions about why there were no referrals of this bill to either Revenue or Ways and Means to look at those reductions. And I never really got an answer. So I'd like to at least put on the record 2 points about the revenue situation. The first is that some of you may remember there was a court revenue restructuring effort that was undertaken in this building after the recession at the request of then Chief Justice Dominguez. And there was a lot of work done to restructure the revenue situation with respect to courts. This is a document, and I'll submit it to the record after the hearing, that came out of OJD's Ways and Means budget presentations last session. And it really shows, I think, graphically the outcome. This is the local revenue that is received from court fines writ large. And you can see after the implementation of House Bill 2710 and House Bill 2712, I think we were in 11 session, those were the bills, the local revenue is about cut in half and is never quite recovered. So you're sort of seeing some sensitivity. There's in the record a document from Deschutes County. My understanding is AOC was split on the measure and so really hasn't taken a position. But local governments are pretty sensitive to the revenue situation, and that's one of the reasons why I'm here. The second point I want to make is that when you look at the allocation of court fines, there is an end of session budget bill that does just that, and it speaks to the statute at 137-300. And there are a lot of state agencies that get dollars from court fines. Typically, over the last 3 biennium, about $70 to $80 million a year. Local governments, particularly counties, depend on many of those programs that are funded through that bill. And I just want to go over a few of them. The DPSST receives the first priority of those dollars. Those are dollars that local governments use to help train up police officers, sheriffs, corrections officers. There's the Oregon State Police receives allocations out of that top tier. For the medical examiner's office, we have local medical examiners that are paid for out of that office and are important for our county operations. OSP also does provide some driving while intoxicated enforcement from those funds. If you go down into the next tier, OJD has quite a bit of money that they get that is transferred to counties for court security programs. Significantly, not this biennium, but the previous biennium, those programs took a 38% cut, which was concerning to counties. There's DOC gets some money for
Alex,
county corrections
I
facilities.
appreciate you pointing these out, but we're getting kind of into the more detail of how each of these agencies, and the reason I'm kind of asking you to summarize, because I got two more people, I have members that are going to need to be leaving, and I'd like to get the public testimony taken care of today.
I think I made a good point, sir. I just wanted to say that, there's this, obviously this is your decision to make, but the policy is broader because we don't have the opportunity to have the Revenue or the Ways and Means Committees looking at this particular issue. So I just wanted to bring it to your attention.
I appreciate that. All right, I'm going to ask if you have questions for.
Real quick comment, Mr. Chair.
Comment.
That what we just heard is that people should be really concerned that you can be ticketed in order to fund certain programs. That's what we just heard.
All right. So thank you very much for the comment. Gentlemen, I'm going to ask if you have other, for our members, if you have questions for these two, please ask them to come by your office to discuss that. Thank you. All right, so our last two individuals that are signed up to give testimony today, Jad Limhouse and Carl Myers, if y'all two would please come forward. While they're coming forward, was there someone else that did not get on the witness list for House Bill 4065? And gentlemen, as you've heard, we are kind of running close to our end time, and I know that some of my members may need to take off, so if you can be succinct, that'd be great.
Excuse me, Mr. Chair, I intend to. Chair Prozansky, Vice Chair Thatcher, members of the committee, my name is Carl Myers. I am the presiding judge in the city of Kaiser, also the presiding judge in the city of Jefferson. I also represent the justices of the peace and the municipal judges in the legislative session, so I come here kind of in that capacity. The two associations that I represent have not taken formal opinions on the original bill, but I received an email this morning from the justices of the peace and a consensus from the municipal judges in support of the amendments as a good compromise to the what we would consider the original bill, throwing out the baby with the bathwater, and a more studied approach and scalpeled approach as opposed to a saw approach to the problems. We all acknowledge that there are problems out there. Our individual courts try to deal with those, and taking away the only real hammer that we have to get compliance from those who can pay is a concern for us. But the -2 amendments seem to alleviate that concern, and we are in support of the -2 amendments. Thank you.
Thank you.
Oh, and I would be happy to answer any questions anyone has on how courts handle these issues, what my courts do if that's important to you, and what we're doing as judges to try to alleviate the problem that has been addressed here today.
Thank you. And John?
Chairman Brzezinski, Vice Chair Thatcher, members of the committee, thank you for allowing me to offer testimony this morning. I attempted some time ago, February the 10th, to send the committee, and not only this committee, but a number of committees, a document by email. Chad Newell this morning told me that it would not.
Chad, I wasn't listening. I don't think you gave us your name for the record.
Oh. I'm Jad Limhouse, a retired Justice of the Peace from Lynn County. I retired at midnight on December 31st of the year 2018.
And you're doing strong. Thank you very much. Please continue.
I was constitutionally limited, by the way. I have several concerns with the bill. I think that the testimony that you heard this morning from all these witnesses, both Mr. Marquis on one side, so to speak, and the folks from the Law Center and the individuals, they all told stories that are true. They're all true. I've heard much of that myself. I was a municipal judge or justice of the peace for 24 years, from December of 1994 until December 31 of 2018. I've heard all those stories. And courts do have lots of discretion, and they don't all exercise that discretion in the same fashion. But there are a couple of things that you can do besides ending this particular suspension that would make the system more fair. If a person is before the Multnomah County Circuit Court on a minor traffic offense and the judge imposes an $80 fine and the person is only able to pay $20 a month, the judge must also impose a $50 fee for that person to enter into a payment agreement that raises that from $80 to $150. If the person can't pay, the judgment becomes $130 that gets assigned to either the Department of Revenue or to a collection agency. So instead of making 4 $20 a month payments, that payment period is extended and the likelihood of failure is extended because of that. The same judgment in the Salem Municipal Court for $80. The judge will allow the payment plan for $20 a month. The judge will tell the person there's going to be a 25% collection fee that will be imposed if you fail to make your payments. So in the Salem Municipal Court, the maximum fine, assuming the person at some point defaults, is $100. It's $130 at the Multnomah County Circuit Court. It's only $100 in the municipal court. The law that requires the circuit court to impose that is ORS 1.202. Repeal that law, and you'll have at least some fairness. Now, the reason the judge imposed $80 was because it's the minimum fine for that particular offense. If the judge hears this person has got a disability payment that is used mostly for rent and utilities and food, and can only afford to pay $20 a month if he or she can scrape together that amount, the judge still has to impose that $80 fine. It's required by statute. Eliminate mandatory fines. Let judges exercise some discretion in setting fines, not just collecting them, but setting them in the first place. So the lady whose mom was, I don't know how many courts she had to deal with, but was basically shut out of the system, if those judges had some discretion to begin with, then maybe she wouldn't have got shut out. There's another thing that you can do. Right now, when somebody goes into default for appearance, on their first appearance, courts can impose the maximum fine for the offense. Suppose a person was cited for a speeding offense on Interstate 580 and a 65. That's a Class B violation. The presumptive fine for that offense is $265. The maximum fine is $1,000. Why are we letting people impose a $1,000 fine against somebody who never had a chance, never showed up in court for whatever reason it was? Why don't we limit that just to the presumptive fine? The presumptive fine is the fine that you folks have decided was the most appropriate fine, all other things being equal. Well, let's just limit on default that presumptive fine. Not the maximum anymore, just the presumptive fine. Let's bring the kind of fairness into the system that used to be there when I took the bench in 1994, 1995. 94 in Sewickley Municipal Court on December 1st, in October 95 in the Justice Court in Harrisburg.
I need you to summarize, finish up. I've got 2 work sessions I still need to do.
Sure. In this missive that I sent to you, I listed a number of things, but one of the things that I would suggest that you do is when you look at that fiscal statement from the Legislative Revenue Office, you multiply by 10 the figures at the bottom of the document, because that's really what the impact is going to be. It's grossly underestimated. Grossly underestimated.
All right. Thank you very much. Gentlemen, thank you very much. And I'm going to go ahead and close the public hearing on House Bill 4065, if I'm not mistaken. Yep. And I'm going to make a statement regarding 4065. As much as the chair would like to move the bill today, we're not moving it today. I was requested by the leadership offices, and I say leadership offices, I want to let everyone stand on their own. Republican caucus, as well as the president's office, asked that this not be moved today. Out of that request, we will not be moving the bill today. It will be set for